Starmer rules out Jeremy Corbyn standing for Labour at next election as watchdog ends anti-Semitism probe. The Labour leader says that EHRC's decision is not the end of the road, but a signpost that we are heading in the right direction, as he confirms his predecessor will not be able to run under the party's banner at the next general election. Now, I'm a bit confused about this story because I don't understand what power the EHRC has and how can Keir Starmer use the EHRC report in order to talk out to say Jeremy Corbyn cannot stand as a Labour candidate. So I wanted to find out about the EHRC and the background to it. And joining us on the show, I'm so pleased that we have with us Sir Geoffrey Bindman, KC, leading human rights lawyer, legal advisor to the Race Relations Board for 17 years, chair of the British Institute of Human Rights since 2005. He won the Law Society Gazette Centenary Award for Human Rights in 2003. I cannot think of anyone better placed to talk about the EHRC, and I'm delighted that you've been able to come on, Geoffrey. Are you receiving me?
Yes, I am. Yes, can you hear me?
I can, yes. Thank you. Thank you for coming on. It's great to see you. Now, I am confused about the EHRC. I didn't really know of their history. Can you tell us why they were set up, and also what precedent there is for the EHRC coming and investigating organisations like they have the Labour Party?
Right. Okay. Well, there was no law against racial discrimination in Britain until 1965. There had been laws set up in America much earlier, and the Race Relations Act 1965 prohibited racial discrimination, but in very limited circumstances, in pubs, hotels, public transport, and so on, public services. There was no prohibition of racial discrimination in employment, housing, or other areas. And so it was a very limited law, but it established the Race Relations Board, which was meant to monitor discrimination generally. And I was appointed its legal advisor early 1966 when it came to be active. And one of the conditions in the Act was that the board would consider the effectiveness of the law and would report to the Home Secretary. And it set up a small committee of 3 people, chaired by Professor Harry Street of Manchester University. The other 2 members were Geoffrey Howe, subsequently Lord Howe, who was well known as Chancellor of the Exchequer and so on, and me. I was the 3rd member. And we reported suggesting that the law should be extended to cover employment, housing, and other areas in which discrimination was a much more serious issue than pubs, although it did happen in pubs. And that new law was enacted in 1968, which gave the board the power to take cases in court against people accused of discrimination. Now, racial discrimination included, of course, discrimination against Black people, Muslims, etc., and included anti-Semitism. Anti-Semitism is obviously a form of racism. And from 1968, cases were brought. I was responsible for running those cases on behalf of the board as their lawyer. And then subsequently there was also a community relations commission, a separate organization not a legal body, but designed to promote equality generally, non-discrimination. In 1976, a further Race Relations Act was passed. This followed the Sex Discrimination Act, 1975, and that combined the two bodies and strengthened the powers of what became the Commission for Racial Equality. Then that body was able to pursue cases of discrimination and monitor discrimination generally in the country. Then we got to 2006, and the Equality Act, which is the present act, was passed, because by that time, in Europe, various other kinds of discrimination were prohibited, like age discrimination, disability discrimination, and some others. And so the laws had grown quite a lot. So a new law was meant to embrace all the prohibitions of discrimination. And the new body was set up, which was the Equality and Human Rights Commission, to monitor those. But unfortunately, it was given, the funding of it has been gradually declining, and therefore its staffing has been relatively reduced, and its activities were somewhat curtailed because it didn't have the funding to deal with what had become a very widespread responsibility. So I'll stop at that point.
So the new body has got more to cover than the old bodies that you were part of.
It covers age discrimination, and of course, anti-Semitism is part of race discrimination, and the investigation we're talking about into the Labour Party was one of the investigations they've set up. Actually, there have been very few investigations conducted by the EHRC, but that is one of them. And what it did was it responded to complaints by some organizations which produced a list of situations in which they claimed that the Labour Party had failed properly to investigate and act against people breaking the law, as they claimed, the law against discrimination in Labour Party situations. So that the EHRC set up an investigation into the Labour Party's handling of complaints, and they were presented with something like 220 cases where the people putting these forward said that there had been breaches of the law, unlawful discrimination. Now, unfortunately, the narrative which we now read, and you referred to that Observer article today, there was another one by Polly Toynbee the other day. They repeat a narrative which is developed, which says essentially that the EHRC found that the Labour Party was riddled with anti-Semitism and found them guilty of breaking the law, and put them under special measures, as it refers to them, in order to improve their capacity to investigate those complaints. Now, this narrative is it's become accepted. I mean, it seems to be common currency among journalism, but it's not entirely accurate, because the investigation which was set up into it was into the Labour Party actually examined something like 70 of the 220 odd cases that were sent to us, and they reached the conclusion that there was unlawful act by the Labour Party in only two of those cases.
Two of how many? 70?
2 out of 220 originally.
Two out of 220?
2 out of 220. Both those cases were individuals, members of the Labour Party, who had been accused of making anti-Semitic statements, either in party meetings or elsewhere. And those two people are both at the moment challenging the findings, but the decision of the EHRC was based on the opinion that the two people were acting as agents of the Labour Party in making those statements. And that's a highly contentious question, and has not been challenged.
Right.
Not been challenged by the party. The two other findings were made by the EHRC. One, that the leadership, when Jeremy Corbyn was leader, had interfered with the investigation of complaints. That was seen by the EHRC as indirect discrimination against Jewish members. Highly questionable conclusion, and one which has been challenged recently by the Ford report, which the Labour Party set up to examine issues surrounding this. And the other case of indirect discrimination related to their training of staff in investigating complaints of discrimination, which they held also was biased against Jewish members, although that again is somewhat contentious. Now, having made these very narrow findings of illegal behavior, they then made recommendations to reform the Labour Party's investigation procedures, and the Labour Party accepted those recommendations, and apparently the Commission has now announced, why we're having this discussion, because of this week, the Commission announced that it was terminating its investigation because it was satisfied that the Labour Party had complied with these requirements to change its investigation process. Now, and undoubtedly, they may well have done that, although curiously enough, I'm aware of a number of outstanding cases where the Labour Party is supposedly investigating complaints and has not concluded its investigation. So the procedures the Labour Party has introduced, the Commission apparently considers satisfactory. But the Labour Party has never challenged the findings that it behaved unlawfully. And presumably because they were related to events that had taken place before the current leadership came into power.
Can I just ask you, because I'm thinking that this report, the EHRC report, has been used by, as you kind of intimated there, by the new leadership to push out the former leader and any of his supporters. And it was quite openly in this press conference. The two issues were put together, EHRC and Jeremy Corbyn's standing it as a candidate, and also anyone who supports Jeremy Corbyn should be shown the door, or whatever he said. Doesn't that undermine the EHRC's integrity, that their report could be used in this way? I mean, shouldn't the EHRC be saying to Keir Starmer, no, this is a serious matter, you cannot use this for your political ends?
Well, that's a very good question. In fact, the EHRC report makes no criticism of Jeremy Corbyn whatsoever. Jeremy Corbyn doesn't feature in the EHRC report. There's no suggestion there that Jeremy Corbyn was responsible for any legalities, although, of course, for at least part of the time that the report concerns, he was the leader of the party. But
so the conclusion that Keir Starmer's made from the report is incorrect in a sense, and shouldn't the EHRC?
Well, I wouldn't say that. I mean, I don't know that he has made that conclusion. I mean,
that Jeremy Corbyn in some way is related to the report is what I mean.
There's been a confusion, really, between three different things that have been going on at the same time. One is the EHRC report. One is the issue of, if you like, factionalism in the Labour Party between left and right, and Jeremy Corbyn and Keir Starmer having different political positions. And the third is the issue of Palestine and views about the conduct of the Israeli government in relation to Palestine. And they've all got a bit confused. So the EHRC report, which has been tried to kind of tread a proper legal path between all these issues, has been, I think, misrepresented, misunderstood, and in some ways that is partly the fault of the EHRC itself. The initiation of the investigation was questionable, I think, because they didn't really have to do that. If all they were concerned about was the method of investigation conducted by the Labour Party into complaints, they didn't need to set up an inquiry into alleged illegal behaviour, which is doubtful. Yeah. So there is, in my view, reason to criticise the EHRC for the way it initiated and conducted the inquiry. But the report has been seriously misrepresented. And as I said earlier, a narrative has been created, which has become the received wisdom in the media and in the political culture.
And I just thank you so much for coming on and clearing this up. And I'm going to bring on a young lawyer who's just graduated and has written an analysis of the EHRC report. It'll be interesting to hear what you think about what he's got to say. This is Ammar Kazmi. Are you there, Ammar?
I am here. Good morning.
I'm just going to bring you onto the screen. There you go, Ammar. Good to see you.
Good to see you too.
What do you think about what Geoffrey Bindman has said, and what would you like to add to it? Because you've written a very long analysis of the EHRC report.
Yes. Just before I begin, I should just clarify that I'm not a qualified lawyer at this moment in time. I've got a master's degree in human rights law and I have a law degree, but I'm currently in the process of becoming a lawyer, hopefully. So just to not, get myself in any hot water from that perspective, I know there must be people on this call who may not necessarily share our perspective, Crispin, but, you know, we should anticipate that. You know, from a legal perspective, my view is, you know, that, and, you know, it's the view of many other individuals, that the EHRC report, you know, is widely considered to be riddled with legal errors. You know, the many of the report's findings were just simply unsustainable and, in my view, absurd, particularly in finding that the former Mayor of London, Ken Livingstone, and the local councillor, Pam Bromley, had contributed to the Labour Party's so-called unlawful harassment of Jewish people. And those are the two individuals, of course, who were out of the original 200, you know, tranche of 220 people who were said to have committed, contributed, to the Labour Party's unlawful acts. And they're now, of course, bringing a judicial review to challenge that. You know, and that was apparently because those two politicians had made a series of, you know, public statements that created in the EHRC's framing, which comes, of course, from the Equality Act, an intimidating, hostile, degrading, humiliating, or offensive environment for Jewish people. And that's all been very widely discussed. Of course, as you mentioned, I've written a very lengthy essay on that, and, you know, we've discussed that on a previous occasion. And, you know, the report is, as I say, being subject to that judicial review, particularly in relation to the matter of freedom of expression under Article 10 of the European Convention on Human Rights. That's a very serious issue, of course, because these were two politicians, and, you know, their freedom of expression is supposed to be actually given an enhanced protection, particularly within sort of English case law and how we interpret that human right. And that case obviously began, you know, 2 years ago, and it should now be heading to court very soon, hopefully this side of summer. You know, these cases frustratingly can take a bit of a time to get going. They have to go through the motions. Lawyers disagree on the way certain things should be handled, like evidence and things like that. So that's contributed to some delay on that front and has caused a need, I guess, to, as you refresh people's memory. Yeah, sorry.
So you're saying the two cases out of 220, that two of them might actually be overturned in some way?
Well, that's the aim of this. Yes, we're certainly trying to, you know, get a declaration from the court that essentially the EHRC has overstepped the bounds by one, not respecting the Ken's and Pam's right to freedom of expression, because the way their legal analysis tries to frame it is that they weren't entitled to say what they said because it was, you know, hate speech or discriminatory. But actually that's not the test. They're supposed to have, you know, the EHRC is supposed to do this very strong balancing process to determine whether actually what they said was lawful or not. And it seems, you know, from our perspective, that they didn't do that. But even if, you know, it wasn't protected, it wasn't, we would say, you know, the threshold of harassment. And there are various other ways in which that's being confronted. But essentially, yes, we'd be wanting to basically say that actually the EHRC behaved unlawfully by saying that, by singling out actually Ken and Pam and sort of using them as scapegoats.
Can I just ask you? Because Geoffrey is talking earlier about the scale of race relations and talking about complaints about racial discrimination. And there's so much that it now covers that wasn't there in the 60s. But the resources of the EHRC have been run down. Why would the EHRC take on this particular case when there's so many other things to be doing? And what other cases have they turned a blind eye to that you could say that should have been something they prioritized, rather than this investigation into two cases? They found two cases out of 200 and whatever. Could you tell us any cases they haven't been investigating you think they could have?
Well, I mean, for example, they didn't launch an investigation into the Conservative Party, into widespread complaints about Islamophobia, not, you know, just from people on the Labour side, but there was a, you know, sort of a big push by Baroness Saeeda Varsi to, you know, tackle that. They haven't focused on that. And actually, I think Geoffrey kind of alluded to it, that this is actually a very strange situation. the only two political parties to have ever been investigated by the EHRC are the BNP, right, the British National Party, a fascist far-right group, and the Labour Party. So actually, the Labour Party is the only political party ever to really have been subjected to a situation like this. And that's why I think we really need to look at this from a political perspective. I think it's, the legalities are very interesting. And if you're not fully on top of the legalities, anyone on this, tuning in, you can access that elsewhere. What I think is very interesting is how the legal and the political intersect, right? Because it's precisely because of the, political ramifications of this issue that we saw, as you mentioned earlier, that nauseating and actually quite disturbing press conference with Sir Keir Starmer that we're discussing this now, because ultimately the EHRC used its quasi-legal powers, in my view, in collaboration with Britain's Israel lobby and the Labour right to actually help achieve political ends. The EHRC investigation was, as I've said on a previous occasion, a very British exercise in lawfare. It was triggered by two pro-Israel and Zionist groups, the Jewish Labour Movement and the self-styled Campaign Against Anti-Semitism. And so the EHRC was essentially, in my view, weaponized as a tool to conduct a political battle against anti-imperialists and supporters of Palestinian liberation inside the Labour Party. Obviously, the legal issues like freedom of expression are deeply important in their own right, because that can, and it has had, in my view, knock-on effects elsewhere. But we should be looking at that through a broader political framework. The removal of the Labour whip from Corbyn, as was actually divulged 3 months beforehand by Adam Kayler, a former hack for the Jewish Telegraph, he might actually still be there, was already on the cards in response to the EHRC report. They were already planning to suspend Corbyn in response to this report. So this report was actually, it was conceptualized, it was used, and it continues to be used as a political sledgehammer to smash the left. So that's why, in my view, whether you're interested in the sort of legalities or not, this judicial review by Ken and Pam is very important. Obviously, on a personal level, they deserve to be vindicated because they've been used as scapegoats to help to attack us, right? All of us on this call. The legalities of the report, because of how flimsy they are, certainly, deserve to be interrogated. But the overarching reason is that we should be trying to draw a line in the sand here. This is an incredibly important thing. This report came out in October 2020, and we can see the ways in which it's being used, and I think it's only going to continue to be used in that way. So that's where I would personally try to draw this, direct this conversation, because we've discussed the legalities. Legalities for me, as someone who studied law, I find them very interesting. Other people may find them interesting, but I think where that intersects with the politics is very, very interesting and very important as well.
Now, now we've got Geoffrey. What would you like to say to round off the case for the? We've had this, I don't know, say it in court, but what would you like to say to round off this discussion?
Well, I focused on the legalities probably more than your last speaker would necessarily consider important, but. I think the legalities are very important here because they have been misrepresented essentially in the media. And I think what I find very interesting is that people, no doubt, with their own axe to grind, with political motivations, have managed to present the EHRC report as a condemnation of not only Jeremy Corbyn but of the Labour Party, and I think that is political, as your last speaker said. I think the political dimension is extremely important,